Welcome to Policy Precision, an unbiased dive into executive orders. I'm Ethan Caldwell, detailing their impacts.
And I'm Nora Harper, looking at their human side.
Okay, let's jump right in. Today we're tackling Executive Order 14159. It's titled Protecting the American People Against Invasion. Signed January 20th, 2025 by President Trump. It hit the Federal Register on January 29th.
Right. So what we want to do today is really unpack this for you. What does this order actually say? What happened right away?
And what were the initial reactions? We're aiming to give you the core provisions and those immediate effects, just the facts.
Exactly. No spin here. So the order itself states its purpose pretty clearly, doesn't it?
It does. It says it's about protecting Americans by, quote, faithfully executing immigration laws.
And it frames this against what it calls an unprecedented flood of illegal immigration in the 4 years prior.
Yeah, it argues that this situation created risks, national security, public safety, and led to crime, burdened taxpayers. That's the justification laid out.
So that's the problem statement. And the policy solution?
It centers on that faithful execution idea, applying immigration laws to, well, everyone deemed inadmissible or removable.
With a special focus on anyone considered a threat.
Precisely. A threat to safety or security. The goal stated is total and efficient enforcement.
Using lawful incentives and, importantly, detention capabilities. Total and efficient. That sounds pretty sweeping.
It does suggest a broad and perhaps faster enforcement approach than what came before.
Okay, so what were the first concrete steps?
Well, one of the very first actions was wiping the slate clean, essentially. It revoked several previous executive orders.
Ah, which ones?
Let's see, EO 13993, that was about enforcement priorities.
Yeah.
Then EO 14010, the one about a regional framework for migration causes.
Okay.
Also EO 42011, which set up the Family Reunification Task Force.
Right, I remember that one.
And finally, EO 140012, aimed at restoring faith in our legal immigration systems.
So canceling those really signals a major shift in direction, getting rid of those frameworks, like the regional one you mentioned, EO 14010, moving away from that cooperative approach.
Exactly. It clears the path for this new policy focus. After the revocations, the order gives specific instructions to DHS Homeland Security.
What kind of instructions?
The Secretary is told to make sure ICE, CBP, and USCIS prioritize protecting public safety and national security.
Meaning enforcing removal orders.
Yes, and it explicitly says the primary mission for ICE's Homeland Security investigations should be dealing with illegal entry and presence.
That sounds like a very direct mandate. Enforcement is priority number one, especially for unauthorized presence.
Which could definitely mean resource shifts within those agencies.
And what about the criminal side?
The order addresses that too. It tells the Attorney General, working with State and Homeland Security, to prioritize prosecuting criminal offenses tied to unauthorized entry or presence.
So more potential criminal charges instead of just civil immigration violations?
Yeah.
That's the significant difference, carries heavier consequences.
Absolutely. Then there's the creation of Federal Homeland Security Task Forces, HSTFs.
HSTFs, what are they supposed to do?
The idea is to set them up nationwide to go after criminal cartels, foreign gangs, and human smuggling and trafficking networks.
With a specific mention of crimes involving children.
Yes, that's highlighted. And the order says to use, quote, all available law enforcement tools.
Okay, so a coordinated nationwide push against those specific types of crime. Highlighting children's cases is, well, often a strong public focus.
It is. The order also touches on identifying undocumented immigrants who haven't registered.
How so?
It directs DHS to publicize the legal requirement for aliens who are supposed to register under 8 U.S.C. 1302 to actually do so.
And if they don't?
Noncompliance is explicitly stated as an enforcement priority for both civil and criminal actions.
So that puts individuals who might have, flown under the radar squarely in the spotlight. It aims to bring more people into the system.
Right. Then there's the money aspect. Fines and penalties.
What about them?
The order tells Homeland Security, working with Treasury, to make sure they assess and collect all legally authorized fines from unlawfully present individuals.
And from people who help them stay.
Yes, exactly. And they had to report back to the president on this within 90 days.
So a push to recoup costs through financial penalties.
Seems like it. Now, for speeding up removals, the order mentions expedited removal.
Ah, the faster process often used near the border.
That's the one. The directive is to maximize its use under INA Section 235B1A3 and also use other legal tools for faster removals like Sections 238 and 240D.
Expedited removal can be very quick, sometimes with limited review. Expanding it, well, that raises due process questions, especially for asylum seekers.
A valid concern. The order also hits on detention
More
facilities.
detention.
It mandates action and resources allocating funds to build, operate, or use detention facilities for removable aliens.
Okay.
The stated goal is to ensure detention while cases are pending or while waiting for removal, wherever the law allows it.
That definitely signals an intent to detain more people during the process. Big implications for individuals and for budgets.
No doubt. Another piece is encouraging more Section 287G agreements.
Those are the federal-state partnerships, right, where local police can perform some immigration functions.
Correct. The order directs maximizing these agreements with state and local law enforcement, provided they consent, of course. It's framed as in addition to federal efforts.
Yeah, those have always been controversial. Concerns about community trust and the role of local police in federal immigration.
True. Interestingly, there's also a bit about encouraging voluntary compliance.
Voluntary compliance, how?
It tells the DHS secretary to adopt policies encouraging people here unlawfully to leave voluntarily,
Yeah.
using things like formal voluntary departure under INA Section 240B, international agreements, that sort of thing.
So alongside the tougher measures, there's this push for voluntary departures. We'll have to see how that plays out.
Then there's the issue of recalcitrant countries.
Countries that don't take back their citizens who are ordered removed from the U.S.?
Exactly. The order directs state and homeland security to implement sanctions under INA Section 243 against those countries where possible, and to work on eliminating barriers to getting people repatriated.
So putting pressure on other nations to cooperate.
Pretty much. Some other points. Setting up a system for visa bonds and bringing back the voice office within ICE.
Voice, remind me?
Victims of immigration crime engagement. It's meant to support victims of crimes committed by removable immigrants.
Ah, right. Focusing on the victims of those specific crimes.
And it directs the Attorney General to uphold victims' rights in those federal cases.
Got it. What else?
Well, perhaps one of the biggest parts is tackling policies from the previous administration.
How so?
It explicitly mandates rescinding policies seen as leading to more illegal immigration. It specifically calls out the use of parole authority.
That's INA 212.5, the temporary entry mechanism.
Correct. Also temporary protected status, or TPS.
Okay.
And the granting of employment authorization work permits under INA 274A to those not otherwise authorized.
Wow, targeting parole, TPS, and work permits is huge. That could change things for a lot of people, like asylum seekers needing parole or TPS holders.
It's definitely a fundamental shift. The order also goes after sanctuary jurisdictions.
The cities and counties limiting cooperation with federal immigration enforcement.
Yes. It directs the Attorney General and DHS Secretary to evaluate and take lawful steps to deny federal funds to them.
And consider other actions.
Civil or criminal actions, potentially.
That brings back the whole federal versus local power debate. Threatening funding is serious leverage.
Absolutely. Tied to this is information sharing.
What does it say about that?
DHS needs to ensure compliance with laws like 8 U.S.C. 1373 and 1644, which deal with sharing info with state and local governments for law enforcement and status verification.
And sharing info to combat child trafficking, too?
Yes, that's mentioned specifically as well.
Info sharing is powerful, but always brings up privacy concerns, you know?
Yeah.
How the data is used and protected.
True. Then there's a review of federal funding going to NGOs.
Non-governmental organizations. The ones supporting immigrants.
Right. An immediate review, possible audit, pausing funds, terminating agreements if they don't comply.
And even clawbacks, trying to get money back.
Potential clawback procedures are mentioned, yes, along with coordinating with the Office of Management and Budget, OMB, on appropriations.
That's a close look at funding for groups working with immigrant communities. Could really impact their operations.
It could. The order also tells OMB to make sure federal agencies identify and stop providing public benefits to unauthorized immigrants who aren't legally eligible.
Restricting access to benefits could affect health, welfare, basic needs for many individuals and families.
It's a significant potential impact. Lastly, the order calls for hiring more agents.
More ICE and CBP officers.
A significant increase, it says. But crucially, it's subject to appropriations Congress has to approve the funding.
Still, it signals an intent to really bulk up the enforcement workforce. Could mean a much more visible ICE and CBP presence.
Definitely the intention. Now, it's really important for you to know this order didn't go unchallenged.
No, I imagine not. Legal challenges.
Immediately. On February 7th, 2025, San Francisco and 16 other self-described sanctuary cities and counties filed suit in California.
Challenging this EO and another related one, EO 14218.
Correct. They were trying to block parts of it, especially the bit about cutting off federal funds.
And did they succeed?
Temporarily, yes. On April 24, 2025, Judge William Orrick issued a preliminary injunction.
An injunction, so a court order stopping something.
Exactly. It prohibited the administration, at least for the time being, from denying funds to these sanctuary jurisdictions or making funds conditional on immigration cooperation.
That's a significant early legal blow to that specific part of the order, holding back the funding threat.
It was, and President Trump's response was quite direct. He was quoted saying, "Sanctuary cities are sanctuary for criminals. We should close them down."
Wow. Shows how deeply divided the views are on this. That legal fight was clearly just beginning.
Absolutely. So wrapping this up, Executive Order 14159 represents a really broad effort to overhaul immigration enforcement.
Prioritizing strict enforcement, boosting removals, targeting sanctuary cities, reversing prior policies. It covers a lot of ground.
And, as we saw, it hit immediate legal resistance, particularly on the sanctuary city funding, which a court put on hold, at least initially.
Yeah, it's clear this order touches so many areas, individual lives, federal-state relations, the whole immigration system.
So hopefully you now have a clearer picture of the key elements of this major policy shift and those initial responses.
It definitely sets a lot in motion. And thinking about those swift legal challenges and just how comprehensive this order is, it makes you wonder, what do you think the long-term consequences will be for policy, for communities? That's something to keep thinking about. We definitely encourage you to keep digging into this topic.
Thanks for joining us for this deep dive.